हेलो एवरीबॉडी, वेलकम बैक टू माय चैनल। तो कल एक क्वेश्चन मैंने अपनी पहली क्लास में ड्रॉप किया था जो था इज़ द पावर ऑफ हाई कोर्ट टू इशू रिट्स वाइडर दैन द पावर of the Supreme Court. So we're going to study this today. So to understand that is the power of High Court wider than the power of the Supreme Court, we must compare two articles. First is Article 226 and the other is Article 32. So Article 226 talks about the power of High Court to issue writs, whereas Article 32 talks about the power of Supreme Court to issue writs. So in Article 32, the constitutional remedies are provided. What are provided? Constitutional remedies are provided, but for what? They are provided for the infringement of fundamental rights. So for example, अगर कोई person है जिसकी fundamental right breach होती है, so he can go to the Supreme Court. Under what article? Under Article 32. So this is what Article 32 is talking about, that if your right has been breached, come under Article 32, the Supreme Court will provide you with a remedy. So the person can directly approach the Supreme Court, whereas in majority of cases a person cannot directly approach the Supreme Court. There is always a procedure that one must follow to reach the Supreme Court for the decision, whereas the right that is provided under Article 32 is guaranteed. Guaranteed means that this right cannot be suspended. What? It cannot be suspended. Just a minute, I'll just write this again. So guaranteed means that this right cannot be suspended. So the Supreme Court under Article 32, if a person approaches the Supreme Court for the infringement of fundamental rights, it can issue these 5 writs. So these 5 writs have been discussed comprehensively in my first class, so I'm not going to discuss them in this class. So if you wish to know what these 5 writs are talking about, you must go to my channel and view my first class that I uploaded on these writs. So moving forward, the Supreme Court can issue these writs for the enforcement of Part 3. So it is only for the infringement of Part 3 the Supreme Court can issue these writs. So the main part of discussion is this part. We must focus on this part, that Supreme Court can only issue these writs under Article 32 for the enforcement of Part 3. But if we come to Article 226, if a fundamental right has been breached, you can directly approach the High Court under Article 226. The High Court can issue writs. So the High Court can issue writs for the enforcement of Part 3, but also for any other purpose. So the difference lies here. The High Court can issue writs for any other purpose as well, but the Supreme Court can only issue writs for the enforcement of Part 3. So this makes the power of the High Court wider than the Supreme Court. But if we on the face of it primarily just compare Article 32 and 226, obviously we'll get the answer that the powers of the High Courts are wider. Whereas if we study Article 139 as well, so it confers upon Supreme Court the power to issue writs for any other purposes. So the Supreme Court also has the power to issue writs for any other purpose, but that power is provided under Article 139 and not under Article 32. So just this is the difference. I hope you understood the concept properly. That's all for today. We meet in the next class. Bye.